The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Peter Sachs. With me are Justices Catherine Hand and Marguerite Grant. We'll be hearing one argument by Zoom today. It is number 22P116, Commonwealth versus Timothy Smith. Each side will have 15 minutes to argue. There is no rebuttal. We have read your briefs. We're familiar with the factual and legal background of the case. So we would urge you both to get right into the heart of your arguments. As soon as your argument starts, a 15-minute timer will appear on the screen and it will turn red when your time is up. So with that, I think we'll hear from Mr. Smith.
Yes, good morning, Justices. This is my first time, so I hope you'll bear with me. But I'm here before you challenging the denial of a Rule 30 in lower court. I would like to, I guess, jump right into the first issue, if I may, and direct your attention to the issue of ineffective or invalid waiver of counsel. And I seek to address your attention to that because that seems to be the more complete record. And if you'll recall, on November 13, 2017, a hearing was conducted in Superior Court in which I was ordered to proceed pro se. During that hearing, when I was ordered to proceed pro se, I was specifically asked by the motion judge if that was my intention. And I specifically said, no, it was not, that I did not, it wasn't my intention to proceed pro se. And we went on to discuss some of the concerns I had with the present counsel at the time, which was Attorney Judicial. At the end of that hearing, I attempted to file a motion, and the judge specifically stated that I was not representing myself. There was a procedure that must be followed. And that procedure turned out to be her declaring that Jerusalem would be standby, and for the rest of the proceedings, I would be obligated to represent myself. And we went on with that, and I subsequently filed, after trial, I subsequently filed Rule 30 with the trial judge. And it was during the memorandum and decision of that denial that I became aware that the trial judge wrongfully or wrongly stated that she also conducted a waiver of counsel colloquy. And
I have a question for you. Excuse me, Mr. Smith, sorry. I have a question for you about the record on that point. And if you don't know the answer to this, I'm going to ask the same question of the prosecutor. In her order, denying that first motion for new trial, the judge has a footnote on the first page saying, after careful, she says that the counsel for the Commonwealth was trial counsel, and this court presided over the trial. After careful review of the Commonwealth's memorandum, the court adopts its facts insofar as they are consistent with the court's memory of particular facts not contained in the court file. We don't have before us the Commonwealth's memorandum in opposition to that first motion for new trial. But it looks from that footnote as though the trial prosecutor said something in that memorandum that may have been what caused the judge to make the findings that there had been a waiver of counsel colloquy before her. Do you know anything about that?
I have no recollection of the Commonwealth's opposition, if that's your question. All I could refer the court to is the fact that there is no colloquy that took place between the trial judge and myself, none whatsoever. So to the degree that she recollects it being a lengthy colloquy, to the degree that she recollects that I was insistent upon representing myself and I was adamant, and that she provided me with certain warnings, those are specific facts that, I mean, given that my liberty was at stake, I would think someone would be a little more careful with the adoption of rulings that, you know, dictates whether my trial was reversed or my conviction was reversed or not.
Thank you.
And that is what leads me, I guess I continue to my point. This record on this point, the ineffective waiver of counsel, the record speaks clearly. I mean, there's no doubt about the transcript provided for the November 2017 hearing. And there's no doubt about the fact that on April 10th, the day of trial in which the trial judge states she conducted this colloquy, there's no doubt that it didn't happen. And it's my understanding that the law provides that if there's no on the record colloquy, then there's no waiver. Secondly, I think it's important to note that nowhere in the record do I request to represent myself. And to that extent, there's supposed to be an unequivocal and affirmative request to proceed pro se. And as I and the Commonwealth noted in our briefs, the question was, Mr. Smith, is my understanding you want to represent yourself? And my response was, I was emphatic that actually that's not my intention.
What do you say to the Commonwealth's argument that at trial, Ms. Jerucham, for all intents and purposes, did represent you and did a fabulous job?
What I say to that, Your Honor, is that between the time of my arrest and trial, 15 months had elapsed. During that period, I was, vociferously complaining about the fact that I never received discovery. I never received an investigation of the charges, the person, or my defense. So to the extent that Ms. Jerucham was able to stand up and, basically complete the trial for me, there was relatively no information or no facts presented that was beneficial to my defense. I actually had a defense. I actually, as you can see from my complaint about counsel written 6 months or 9 months before trial, my complaint was that there was exculpatory evidence available. It just had to be investigated and retrieved. And my complaint all the way through to the eve of trial was that no lawyer conducted it. So I'm not, and I had not spent much time thinking about what Ms. Jerucham did at trial, because in my mind, I couldn't distinguish between whether I was represented by counsel or whether I'm still considered pro se.
Mr. Smith?
Yes.
I wanted to ask you, Judge Ullman denied the second motion for new trial in part on the ground that some of the issues you raised there, including the issue regarding waiver of counsel, was subject to estoppel because it had been litigated in the first motion for new trial. I understand your position to be that you didn't raise an issue of waiver of counsel and that the judge ruling on the motion for new trial, the trial judge, kind of injected that issue into the proceedings, and therefore you shouldn't be held to the outcome. However, when she injected that issue into the proceeding and denied your new trial motion partly on that basis, you appealed, but you did not press the waiver issue. Perhaps because you didn't have the transcript at that time, but the Commonwealth's argument is, well, you chose to bring that motion for new trial before you had the transcript, and that was your decision. So what is your response to whether you should be held to the outcome of the first motion for new trial and the appeal?
Well, Your Honor, I can't apologize for strenuously maintaining my innocence. And I was convicted of a crime in which I did not commit. And when I filed the initial Rule 30, it was a mistake for sure in retrospect. But at the time, I just wanted to be heard and I wanted the issue reviewed. That it was not raised, I think is relevant because if it's not raised, then I never litigated this issue. I never argued this issue. This was something that I heard nothing about or knew nothing about until the trial judge issued her decision.
Right. But once she issued that decision and said you had waived counsel, wasn't it your option to challenge that when you appealed the denial of the motion and say, I don't know what the trial judge is talking about. I never waived counsel, even though you didn't have the transcript at that point? I mean, surely you had some recollection of whether you had engaged in a waiver of counsel. Well,
The other part to that answer is that I was appointed counsel, Mr. McKenna, and given my experience up to that point, I kind of allowed him to do what he thought was best and necessary rather than to inject my beliefs or my position as forcefully as I tried to do in the lower court unsuccessfully. Secondly, it's rather difficult to argue an issue with lawyer or with the court if you do not have the evidence to support your claims. So when I told him that I had no recollection of this hearing with the trial judge, he ordered the transcripts for November 13th because his position, and I understood, was that if the waiver was conducted in November, then it's irrelevant whether the trial judge conducted one or not. And that's where it was left at. So we had to wait until we received the November 13th hearing transcript. Because if that was a valid waiver, then it didn't matter. Go on, I'm sorry.
Yeah, no. Sorry to interrupt. But when was that transcript received? Was it during the pendency of the appeal from the denial of the first motion for a new trial?
Yes, it was. It was received after briefs were filed. I believe the docket entries, which is a part of this motion, and I referred to it in my brief in terms of the actual date in which the transcripts for November 13th was received. Okay. And that was after the briefs were filed.
So was that transcript before the panel in the first appeal, the panel of our court?
No, it was not.
Okay.
Was the November 13th transcript?
Right.
Right. No, it was not.
Okay. May I ask you a question about your argument regarding the falsification of testimony at the grand jury and the trial? I understand there's some differences between how witnesses testified at those proceedings and what might have been shown in police reports and other documents. But what evidence is there that the Commonwealth knowingly offered false testimony?
My evidence would have been, again, I refer you to the court docket entries to show the numerous motions I filed requesting copies of, because as I stand before you now, I still do not have copies, hard copies of the entire file. I have a disc, and here in prison, the disc cannot be copied. So when I say the Commonwealth knowingly interjected knowingly false testimony, I'm referring specifically to instances where the alleged victim claims to have been knocked unconscious, where the Commonwealth was in full possession of at least 6, 7 medical entries from doctors who specifically asked and noted that she was not. These were doctors who saw her within 24 hours of the incident.
Okay. But does the Commonwealth know which version of the facts is the true one? the one that is testified to at trial versus the one that was reflected in the records?
I believe, Your Honor, that if there are 7 independent reports of an issue or a point on an issue, in this case, again, I refer to the victim claiming to be unconscious, and then the victim suddenly claims that she was not knocked unconscious, then I think it's incumbent upon the Commonwealth, who was trying to deprive me of my liberty, to at least question this alleged victim about which version is true. You know, I had became aware, again, if you refer to my argument about constructive denial, I did not receive the full discovery, and I don't even know if it's the full discovery, until the eve of trial. I provided the court with transcripts of a hearing conducted, I think it was April 2nd, in which I'm still battling with Jerusalem about discovery, and that the Commonwealth provided to her a long time ago. I just never received it until the eve of trial. And that included the information that I'm referring to now, the medical reports. So that's the extent of it. You know, I could only hope that the Commonwealth would be a little more meticulous about testimony. I mean, the record was there.
Mr. Smith, your time has expired. Let me just look to the other panel members to see if they have further questions.
Okay.
And I don't see any, so we'll leave it there for you, and we'll hear from Assistant DA Jordan for the Commonwealth.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. If I could just turn immediately to Justice's Grant, a question about the record and the Commonwealth's opposition to the first motion, the defendant's first motion for new trial, which according to the trial docket is paper number 62. I had a chance to review it, and there is nothing beyond what is already in the record for this appeal. It seems that the footnote that Justice Briger was referring to had to do with more the statement of the facts that the trial prosecutor included in her opposition to the first motion for trial because the transcripts weren't available or weren't provided by the defendant in support of his motion for a new trial. So there's nothing that refers to an additional colloquy or anything of the sort. I would argue, and I'm happy to submit if the court wants me to reopen the appendix. There's nothing extraneous besides what is already contained in the record before this court.
Is there any written waiver of counsel in the record?
There is not. My perusing of the record, the colloquy, the waiver, I believe is really isolated to what is included in the transcript here with Judge Miller's exchange. And then I did look at some other interactions with the court and the defendant where there's acknowledgement prior to the hearings. I think I do cite it in my brief saying, okay, you're representing yourself pro se here, and Attorney Jerusalem is your standby. So there was repeated references and opportunity for the defendant either to correct that statement and an opportunity for him to consult with Attorney Jerusalem to revisit that as well. And numerous times, the defendant also argued, for example, motions in limine on his own. And as far as I can see, there is no motion, for example, motion in limine prior to trial, saying or challenging his waiver of his right or his challenge to standby counsel. And I do mention this in my brief, but the defendant at this point had already fired 2 other well-practiced attorneys, and the Attorney Jerusalem is a very seasoned attorney as well. So the defendant is fairly aware that he had a right to counsel and fully aware how to interact. He did have a criminal record before this case. So
but what do we do with the cases like Francis that say that a violation of the right to counsel is structural error?
I think this this record is clear that the defendant, it might have been an express waiver as an exchange of the defendant says, the judge asked this question, the defendant responds in this way, But I think it doesn't have to be an express waiver when it's done in this constructive way, where the defendant has an awareness of what his rights are. He knows he's entitled to an appointed attorney, and he's expressly holding himself out that he does not want to cooperate with that and wants to file in the relevant hearing, wants to file his own motion.
But where is he clearly informed that by filing his own motion, he will be essentially forfeiting or waiving the right to further representation by an attorney? I
could just cue up that the hearing with the colloquy, or the hearing, I guess is a better way to talk about it. The hearing with Judge Miller, she basically says, are you sure that you want to file your motion? Why don't you have another break? This is a very experienced attorney. You shouldn't file your own motion to dismiss. She already has one ready to go. And he's like, no, this is it. This is my one I want to file. So,
right. But she never quite says, if you file this motion that's in your hand there, you will be waiving your right to counsel during the rest of this proceeding, including the trial.
Well, she next says, I understand that you want to do that, but Judge Miller doesn't leave him, if you will, hanging. She says, I'm going to appoint her standby. So I think she tries to strike a balance.
Standby counsel is not full counsel.
Right. But I think Judge Miller is trying to strike a balance between a defendant who maybe in parents loca almost says, I don't think that you should do this on your own. I'm going to appoint standby counsel. But I think in a way, this is a little bit, I think it's kind of watered down when we look at actually what happens at trial, because the defendant basically lets attorney or concedes that Attorney Jerusalem is his attorney midway through the first witness, who is the victim. So if we're looking about what rights and what critical stage the defendant's rights to counsel were at all even infringed, I would argue that he was represented by Attorney Jerusalem. She, as I point out in my brief, argued a motion for a directed verdict, which resulted in the judge's allowance of that motion for one of the most serious charges. And then later, the defendant is eventually acquitted of the most serious charge that's remaining in rape. So I would argue, if we're looking at what the waiver was, and the Commonwealth argues that it was a constructive waiver, that hearing, based on the defendant's experience, the fact that he knew that he was what it meant to have an appointed counsel due to his experience, and fact that he had already fired alone in this case.
When you say his experience, I think you mentioned a moment ago prior criminal record and experience with the criminal justice system. Is there anything in the record about that? I couldn't find it.
I did not include his Corey as a part of the impounded record. I try not to do that.
And to the extent that the habitual offender indictment refers to past convictions, that indictment was dismissed, right?
Correct. It eventually was dismissed, but to your Honor's point, it did result in an indictment, meaning there was at least 2 convictions. And I know what those convictions are a part of the transcripts. I would have to take time to look at the site, but I know that those are referred to perhaps in the grand jury minutes. So again, thank you. That would be an inferential that if he was eligible for an habitual offender indictment, that means that at least 2 other occasions he had received a state prison sentence. I'm not sure, are there any other questions for the panel for me?
Is it fair to hold him to estoppel on the waiver of counsel issue where he didn't have the transcript?
I think
first motion in the trial.
I would argue
the reason he's filing his first motion for new trial pro se is because he doesn't have counsel anymore, because he supposedly waived it. But so how can he be held, if there was no valid waiver, how can he be held to the consequences of waiving counsel and therefore moving for a new trial without the benefit of a transcript?
Well, I'd like to answer your question in 2 parts, because post-conviction, he could have applied for appointed appellate counsel after his conviction. So I think the fact that he didn't seek appointed appellate counsel, I think he has to kind of cross that threshold first. And I think if we're going to say, well, he didn't know to get the transcripts, I think we're kind of sliding in the muddy waters of the procedural rules are applied unequally to pro se defendants. And I don't think that would be, this court would.
Right. But the fact that he was pro se presupposes that there was a valid waiver. So, I mean, usually when we think about estoppel, we think about whether a party had a full and fair opportunity to litigate some issue. If he was doing it without benefit, trying to litigate essentially effectiveness of counsel without benefit of counsel, because he'd supposedly waived it, is it fair to hold him to the outcome of that particular phase of litigation?
Well, I guess you have, no, I guess you'd have to resolve the first issue before addressing the second. But I think the record itself establishes that even if you're saying that the waiver, that there's an issue with the waiver, what actually happens, he's not prejudiced because at trial, again, it reflects on these critical stages. He was afforded Attorney Jerusham's counsel repeatedly. So he basically doesn't have counsel if we're going, I'm assuming that the Commonwealth does not concede that point, that he did have counsel. So it's almost, he's saying I didn't have counsel, but when in effect, he did have counsel. So I think that argument kind of fails.
But he had no counsel at the time he filed his first motion for a new trial, and he didn't know or didn't understand the risks of doing that without a transcript.
Sure, but I think, I mean, the next question would be, what kind, do we need to have another colloquy before a pro se defendant files a motion for a new trial?
Not necessarily if there was a valid first colloquy, but when you look at the November 13th hearing transcript, one can raise a question about whether that was a thorough colloquy.
Right, and I guess the Commonwealth's argument is that it doesn't need to be a colloquy where there's this formal exchange, but based on the defendant's actions and the totality of the circumstance, that it was clear that he knew what rights he was waiving and the seriousness of those rights. And that's the crux of the waiver. Is it knowingly involuntary? I would think that to say there's some specific magic words that had to be said to either by the judge to him or to him to the judge, I would think would kind of water down what really is at issue. Was the defendant deprived of an assistance of a qualified counsel when it really mattered? And I would think that based on the totality of this record, I would say no, based on that hearing and looking at the trial. I just don't not think that the defendant has established his claims and that the judge properly denied his motions for a new trial.
Isn't a colloquy supposed to include some mention of the consequences of a loss at trial? In other words, Mr. Smith, you know that you're facing X years in prison if you lose at trial. Are you still sure you want to represent yourself?
I don't believe there's any express what the maximum sentence is has to be explained to them. It's not as if it's a plea where the defendant is waiving the rights to.
But there has to be some sense of the seriousness of the charges and what's at stake. I didn't see a discussion of that on November 13th.
Absolutely, but I think at that point, if you recall, the defendant I'd have to look what point Attorney Jerusham was appointed. I'd say maybe 6 months in. I'd have to, don't hold me exactly to that, but I know he had been represented by 2 attorneys. There has been a pretrial motion already filed. So we're already in litigation where he knows he's charged with rape, strangulation, and at that point the habitual offender indictment was still standing. So I think to say that the defendant didn't know the gravity of the charges of the potential prison sentence, usually I agree that the number wasn't told to him, but I don't think that really there's no ignorance, I think, that could be pleaded that he didn't know the seriousness of what he was facing. Okay. Seeing there's no other questions from the panel, the Commonwealth rests on its brief. Thank you.
All right, thank you both for your helpful presentations. The case is submitted. We'll resume our other arguments live in the courtroom. Thank you.